The sociological school of jurisprudence, as its name implies, focuses on the relationship between law and society. Since the scholars of the school place focus on the law-society interrelationship, we can be assumed that the fundamental goal of the sociological school's founding is to study the relationship between the law and the society. Therefore, our statute known as Social Media Defamation Act 2022 aims to study the importance of law towards social media usage to avoid any act of defamation that can disrupt the social interest. I will interpret the importance of the provision to combat the social issues in our country concerning the slander or libel that might happen or already happen on social media today. Following that, I will explain the relationship of sociological jurisprudence with the section and provision in this act through the interpretation or explanation laid down by two scholars, which are Roscoe Pound and Rudolf von Jhering. Roscoe Pound is the major sociological scholar in the United States who is also a prolific writer and a dean of the Harvard Law School from 1916 to 1936. His approach enables society's members to make efforts to safeguard their interests and ensure that their views are heard. As a result, the interests of society and the interests of the state would be reconciled. This approach can be seen in the case of An Tian and Government of Malaysia, where the Federal Constitution protects the interests of society. The Parliament cannot enact laws based on its whims and fancy because the concept of constitutional supremacy exists as per Article 4 of the Federal Constitution of Malaysia. In relation to our Statute of Social Media Defamation Act 2022, Part 2 and 3 in the statute, which comprises of Section 4 until 9, can be a clear illustration that while an individual is permitted to use social media in Malaysia, it is still up to certain boundaries to ensure that the freedom that has been granted will not be misused to do harm or injury to the society or others. As a result, the aforementioned rules define what constitutes as a defamation, which includes slander and libel, as well as the liabilities of those who make defamatory words and the social media service provider that allow defamatory remarks to be publicly broadcast through their application. To further explain, per Section 9 of the Social Defamation Act 2022, the social media service providers such as an Instagram, Facebook or YouTube should firstly inspect the post that wanted to be posted publicly by their users. Then they should take down, investigate and suspend the account that tried to post any defamatory contents towards other people. This action is vital because most of the defamatory remarks made on social media may cause issue to the social or community as it usually contains information that causes harmony or disunity. For example, according to Section 12 of the Social Media Defamatory Act 2022, defamatory words posted on social media about the educational institution may create chaos. The public may make false statements or spark a scandal that tarnishes the institution's reputation and that of its students. Thus, defamation on social media should be combated because it has negative consequences even in the eyes of the sociological jurisprudence itself. Roscoe Pound presents his social engineering hypothesis in which he compares lawyers to engineers. Engineers are expected to apply their engineering knowledge to the creation of new goods. Similarly, social engineers are responsible for constructing societal structures that involve two important goals, which are to maximize enjoyment or happiness while minimizing friction. In other words, the use of law is to balance the opposing interests of individuals and the state. Law is a body of knowledge used to carry out a substantial part of social engineering. Law is employed in society to resolve conflicts of interest and difficulties. He further stated that everyone has their own personal interests, which he considers more important than others. The goal of the law is to strike a balance between the people's interests. For example, Article 10 of the Federal Constitution gives freedom of speech to the citizen, where we can conclude it as an individual interest. However, there are still some restrictions or limits set out in the provision. For example, in accordance to Section 13 of the Social Media Defamation Act 2022, although all users have the right to use the social media to write a statement or post a video or photo about any issue relating to the patriotic or national identity, they still can be found liable if their contents or post harms the image or cause disrespect by society towards person, culture, or things that carry the significance of the country. An illustration for this situation is when a person wrote something in Twitter that tarnished the image of the royal family or the politician from some political party that can bring disharmony towards the society, as each person might have their own interests or support which cause them to fight about their opinions. Furthermore, as sociological jurisprudence focuses on the interests of the society, the right of an individual might not be considered if it causes harm to society. Pound says that for the law to be regarded as effective in society, it must be appropriately and accurately formed to meet claims and wishes. It must be constructed while considering societal demands. When a conflict of interest arises that leads to the acknowledgement of a new interest, the idea of juror postulates must be applied. Some of the standards of juror postulate are that people should act in a good faith when dealing with society and not cause injury, or in other words, avoiding bad faith actions such as defamation. For example, in the context of a religion, a person may be halted from posting any contents in the social media which might tarnish an individual who brings the image of Islam, or a person manifests high devotion to a deity with a certification of tawliah, such as an ustaz or pencetus ummah, as been mentioned in Section 14, Clause 1 of the Social Media Defamation Act 2022. In accordance to Subsection 5 of the provision, the defamation remarks usually been made involving the past or history of the person mentioned under Subsection 1 just now. For instance, each person has the right under Article 11, Clause 1 of the Federal Constitution to profess or propagate their own belief. However, this individual interest might be halted if it will give harm to the social interest. For example, a well-known TikTok user has the individual right to use his or her influence to teach others about awrat or the proper way to dress in Islam. However, they may be found liable to defamatory action if they use a provocative and seductive photos or videos of the repentant celebrity who becomes a religious influencer. From a sociological point of view, this is incorrect and wrong because while the TikTok user has an individual interest in posting the contents and to profess their own belief, it still causes chaos into the societal interests. After all, the religious influence reputation has been tarnished. The public will be skeptical about any religious matters or issues that will be brought or spoken out by the said influencer. Now, I'll interpret the provision by relying on the explanation given by the second scholar of the sociological jurisprudence, which is Rudolf von Jhering. Rudolf von Jhering, known as the father of sociological jurisprudence, was a German legal researcher. He emphasized that legislation exists to serve the individual's interests while keeping the greater benefit of society in mind. Individual is happy when society is happy. His legal doctrine is founded on social utilitarianism. The core law is the role it can serve in people's social life. Law exists to defend societies and individuals' interests by coordinating those interests in order to reduce the likelihood of social conflict. In the context of women, Section 10 of the Social Media Defamation Act 2022 aimed to provide a safety and secure social media platform for women to post or upload contents, either written statement or video or photo. The purpose of this section is to minimize the possibility of slander or libel towards women. As been expressed by Jhering, when the society is happy, then the individual will be happy too. The concept of social utilitarianism might fail to be achieved if the women feel harmed or unhappy to post any contents because they fear that they might be defamed by any person who will use their photos, statements or videos posted on the social media for purpose relating to adultery or unchastity. Therefore, subject to subsection 4 of the provision, any person may be liable to the imprisonment maximum of 1 year or fine not exceeding 50,000 ringgit or both if found guilty to spread any defamatory posts or contents with regards to women. This interpretation could also apply to the minor under Section 11 of the Social Media Defamation Act 2022. Any parent should not feel harm when posting their child photo or video in the social media. Therefore, this provision prohibited any person to share any contents relating to the minor with or without the consent of their parents or guardian if it related to the defamatory posting either towards the minor itself or other people or entity. In conclusion, according to Pound's notion, in order to produce a well-balanced society that fulfills their interests, greater benefit for a greater number of people, it must consist of two elements. First, maximum satisfaction with the least amount of friction. Second, the consideration prior to the juror postulates. Furthermore, Rudolf von Jhering believed that when individuals are happy, then the society will be happy. As a result, the Social Media Defamation Act of 2022 was designed to strike a balance between individual and social interests in order to ensure that the society is free of any issues or harm.